Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us Chris Farish. He's a divorce lawyer like me. He also does a lot of collaborative, a lot of mediation, and some litigation. He also is a past president of the International Academy of Collaborative Professionals. Welcome, Chris.
Thanks, Melinda. I appreciate you having me.
Oh,
I'm excited to be here.
So glad you're here. So, International Academy of Collaborative Professionals, that sounds important.
It's important to me. The IACP is a international organization that promotes collaborative practice and consensual dispute resolution around the world. We have members in 26 different countries.
Wow.
Which gives you an idea of the expansion of collaborative practice in general. Collaborative divorce is really spreading all around the world as a better way for parents and just for couples to decouple, as you've probably heard those catchphrases.
In case somebody in our audience doesn't know, what are we talking about? What is collaborative? Give a little definition, if you don't mind.
I'll try to be brief. I can talk about this all day long, but collaborative divorce is an alternative to a traditional litigation model. So the biggest piece is that both clients, the spouses, the parents, represented by counsel, are going to contract together to not go to the courthouse. And they're going to bind their attorneys to that process. And that's kind of one of the linchpins of collaborative, is that withdrawal provision. If either one of the clients decides they don't want to move forward in collaborative, their attorneys have to withdraw, and they have to hire litigation counsel to take them to the courthouse. The reason that's important is because then you take away the threat of litigation, the threat of running to the courthouse, away from the attorneys, and they can focus primarily and entirely on helping the couples resolve their issues that they have.
Oh, that's good. That's a good description. Thank you. So, is collaborative a law or a statute? And is that true here? Is it true everywhere, that in the international circles?
So we do have what's called the Uniform Collaborative Law Act. About 3 weeks ago, the American Bar Association actually endorsed the Uniform Collaborative Law Act. And in Texas, we've had a statute for going on 20 years now. And we adopted the UCLA several years ago, probably close to 10 years ago. So it is statutory. It is recognized by the courts, is recognized under the law. And it is a legitimate way to divorce.
Are there laws similar to our Uniform Act in other countries?
There are. I don't have the exact number in the United States. I believe we're somewhere around 26 to 28 states who have adopted the UCLA or some version of it. And then in other countries, Australia has a Uniform Collaborative Law Act. Canada has a Uniform Collaborative Law Act. It doesn't mirror our UCLA exactly, but they've used that principle to build their own laws so that they are recognized under the laws of the family laws of Canada and Australia, and in several other jurisdictions as well.
So I know from personal experience that one of the services that IACP, the International Collaborative Practice, provides is they put on a big conference.
That is true. For several years in a row, we've done what's called the International Academy of Collaborative Professionals Networking and Education Forum. This year, there's been a pivot. The IACP is partnering with different groups all around the world to encourage attendance at regional conferences rather than having a singular event, which is normally in October. We've just found that it's easy. I say we. I was the president for so long and on the board for so long. I still say we, even though it's they now because I'm not in there. But
you're a past president.
That's right.
Never
that's
to
right.
be forgotten.
So I think what they found is that lots of people were coming, and it was such a great, wonderful, wonderful event. You never, as a collaborative professional, and I know that you feel the same way because you've been there to several forums, when you're surrounded by like-minded individuals who are all promoting collaborative practice from all over the world, it really just ignites a fire. It just fans that flame that tells you why you do this, why you promote this, why you believe so strongly in this particular process over the litigation process.
Well, we do have great trainers in Texas too, and that come to Texas. We're good about bringing people here. Our statewide organization, which I know you've also been involved with, is currently called Collaborative Divorce Texas. Used to be called Collaborative, what was it called?
The Collaborative Law Institute of Texas.
Yes, so we had a little name change to make it sound more like what we're really doing.
Right.
Collaborative Divorce. One thing that people misunderstand, I think, is what the difference between collaborative and mediation are.
Yeah, so that line is blurred in some jurisdictions a little bit. There are jurisdictions where collaborative professionals perform mediations for sometimes even unrepresented clients and help them to create interest-based solutions. In Texas, we traditionally do what's called positional bargaining in our mediations, where clients are in a room with their attorney, and the other client is in another room with the attorney, and the mediator shuttles back and forth through what we call caucused mediation. And really, the mediator's job is to essentially pull people off of their positions and try and get them closer together so that maybe they will resolve their conflict. You're really worried more about what it is they want and what they will give up in order to get something else they want, rather than why they want it. And if you try to figure out why they want it, you're focusing on their interests. And that's really the primary change, is the fact that you have a client-centered, interest-based negotiation process versus positional bargaining and mediation.
So collaborative is the more interest-based.
Yes.
And mediation is done in litigated cases, right? Like before you go have your trial, you try to settle a mediation, and very high success rate. But you could also use mediation in collaborative.
Yes. Before, as I mentioned earlier, you can terminate the process. You can decide you're going to go to litigation. And as you said, at the courthouse, the judges are going to make you go to mediation, especially if you have children. If you haven't mediated, they're not going to let you go to trial before you mediate. So you might as well, before you terminate the collaborative process and say we're going to litigation, give mediation a shot. See if you can pull it together and resolve whatever those few impasses, because usually it's one or two small pieces.
And that's usually kind of a last-ditch effort in collaborative.
It is.
It's not the go-to on the normal.
No.
So in Texas, somebody's allowed to represent themselves, right? They
Yes.
could go file their own petition for divorce or their answer to someone else's petition for divorce and go to the court and tell the judge what they think. They're held to the same standard as a lawyer. They have to put on evidence properly and all of that. So it's not a great idea, in my opinion, but they're allowed to do that. Is in collaborative, can someone represent themselves?
So the collaborative law model and the collaborative law statute requires both parties to be represented by counsel. That is primarily because part of the collaborative law process is that it is client-centered. And so often in the couple dynamics, you'll have a power imbalance. One client will have more power, will have more knowledge, will have more information than the other. By making sure that both clients are represented by counsel, you can even out some of those power imbalances, and you can have a little bit of checks and balances and make sure that both clients have all the information that they need.
In collaborative, we often work with a team. Talk a little bit about the neutrals on the team.
So it's one of the best things about collaborative is the fact that you don't have to pay your attorney to do all the work, right? So I work with clients all the time, helping them to develop a parenting plan, and in litigation, arguing with them, with clients, or having clients argue with their spouse about what their parenting plan should be. In collaborative, the clients get to go together and talk to a neutral mental health professional who is not there to provide them with any counseling services and is not aligned with either party, and is just there to help them understand their options and to make decisions about what they're going to do with their children, how they're going to handle their parenting time. You have the option of having a child specialist who speaks to the children and gives them a voice, not a vote, but a voice in the process, which can be absolutely astounding. Parents are often just dumbstruck by the fact that their children really do have an opinion about what they do, moving forward. And then you also have a financial professional who is neutral, who is not there to provide investment advice or anything of that nature, but they are there to gather all the financial information and make sure that they have it all, so that you're saving money because you're not doing individual discovery, which many people don't really know what discovery is, but in a litigation case, you do discovery and ask for 160 different categories of documents, and 10 banker boxes show up at your office, and your lawyer's digging through all this stuff trying to categorize it, and takes a ton of money, and you're doing it twice. So in collaborative, you save money because you have one individual who is pulling together in a neutral perspective all of the financial information and sharing it with everyone.
Yeah, to your point, when people say to me, well, that sounds expensive, all those people, I say, well, you're fee shifting from the lawyers to the neutrals. And usually the neutrals are at a lower hourly rate. And now you're paying one person to do it instead of the two lawyers to do it. They're certainly less their hourly rate than the combination of the two lawyers' fees.
Yes.
So that's an advantage.
Yeah, the one thing that I've noticed with collaborative divorce is that the initial outlay is what really makes clients kind of question, because you're retaining an attorney on both sides. So whatever those retainers are, $7,500, $10,000, whatever it is, right? And then you're also retaining these two neutrals.
Yeah.
And they're usually $4,000 to $5,000 retainers.
I agree.
So the initial outlay, that $25,000 or so
Yeah.
right off the top, seems hard. But if you both retain attorneys and then you go to the courthouse and you need a business valuation, well, then the retainer's $25,000 for your business valuator, and then you're both doing it. I mean, you have to get past that initial outlay and understand that in the long run, you really do save money.
Yes, agreed. So we mentioned Collaborative Divorce Texas, which is our statewide organization. And one thing that they provide is training, so that when you hire this neutral, you're not just hiring some neutral banker out there. You're hiring someone who's actually been trained in this process. So tell us a little bit, like, how would someone find that training?
So probably the easiest way is to go to the Collaborative Divorce Texas website, which is collaborativedivorcetexas.com, and go to trainings. And there's a basic training in Austin in September, I believe. There's an advanced training here in Dallas in June 28th. So the basic training is it's an interdisciplinary training, learning to work with the team. And you know it well because you've trained.
I'm one of the trainers.
Times, right. But it's really kind of the doorway into collaborative practice. If you're an attorney, if you're a mental health professional, if you're a financial professional, there is no requirement that you have this training, but most people are not going to want to have a case with you if you haven't. But being that we have a statute, attorneys can take on a collaborative divorce case without any training whatsoever. But many people who try that ultimately find that they don't like the collaborative process because they don't understand it.
They don't know what they're doing. Right. I don't mind working with somebody on, who represents the other client that isn't trained, if they're open to being trained by the rest of the team in the background, and if the neutrals are really strong, meaning they're trained and they've been doing this a long time and I've been doing it a long time. I feel like three of us can prop up the fourth.
I generally agree. Although I will say I would prefer it be someone who's gone through that interdisciplinary basic training and maybe hasn't had a case.
Yeah.
Versus someone who said, well, I guess I'll give it a shot.
Yeah.
But you're right. If they're open and willing to have an open dialogue and to learn in the process, the training is really, it's a benefit, but it's not absolutely necessary.
Another service that Collaborative Divorce Texas provides is they credential people so that if somebody in the uh, community was looking to hire a professional, they could know who's really knows what they're doing in this area or has a little bit more experience than somebody else. And you're credentialed by Collaborative Divorce Texas, and it's not an easy process to get credentialed, right?
It is not. We are fortunate to have a credentialing process. I think that it really puts out there a different level of collaborative training and education, but it's really, really difficult. There's a number of cases that you have to have. It's either 8 in a span of 3 years, or 20 over your career, which doesn't sound like a ton, but it really is. And not only that, but you have to be able to prove who was on your team, prove that you entered into a participation agreement, because if you didn't enter into a participation agreement, it's not a collaborative case. And you have to have continuing education. You have to have not only a basic training, you also have to have 2 advanced trainings. You have to have gone to 3 of the past 5 years at the Collaborative Spring Conference, co-hosted by Collaborative Divorce Texas and the State Bar. There's a lot of training and education that goes into it as well.
It's definitely, if you find someone credentialed, they are committed to this work. They know what they're doing and they believe in it. They're spending a lot of their time, energy, and effort towards collaborative.
Yes.
So it's a nice service to provide, and it's arduous to get their credentialing, but then you can be proud of it, right? So you've been doing this, I think, since 2008. Is that true? It's a long time.
Yeah. So my first training was in 2008, and it was not my last.
What have you seen change in your practice or the practice as a whole from your observations, in your involvement with the international organization? What have you seen change in the practice of collaborative over those years?
It's interesting because collaborative has kind of experienced growth and then a little bit of a shrinking and then growth again. And I think we're in a period of growth right now where there's a lot of collaborative cases out there. There's a lot of public awareness, and there's a lot of those in the public who are really striving for and yearning for something different than a War of the Roses type scenario. And what I've seen is you have to understand that I've gone from being a low-level associate during those years as well to being a partner in my firm, and just the way that my personal practice has evolved. It kind of leads to the change, but really what I'm seeing the most of is dedicated and well-trained professionals. There was there were certain professionals who were trained, and then certain professionals that were training their associates, but the number of trained professionals really wasn't growing, and maybe some of the training wasn't quite as strong. But at this point, we've developed our process, what they call the Texas team model, as you mentioned. And I think we've developed it to such a point that really the training has gotten better and the practice has gotten better.
One thing I've observed, and one thing I like about collaborative, is we do teach a model. There is a roadmap to follow, so to speak, but there is flexibility in it as well. And what I've just learned from doing this a long time is to be aware of and try to recognize when we should veer off the roadmap a little bit. As an example, our training teaches us, and our practice is typically that we're all in the same room. So the clients are sitting next to each other. I'm sitting next to you if we're both the lawyers, and then the neutrals are maybe at each end of the table. Or if it's a round table, they're in there somewhere. But some people cannot do it in the same room. They've had too much conflict in their marriage, or somebody has felt bullied, or for a variety of reasons. That would be a reason they might not select collaborative, is when they hear that. Well, it's not required by the statute that we sit in the same room. Right. So we could do a whole case either on Zoom, so then they could be in different places. So they're still in the same room on a Zoom. It's an electronic room, but they're not physically in their presence. That might give them the comfort they'd need or a little bit of distance to feel more comfortable. Or we could do it caucus style, like you described mediation, where we're in the same building, but we're physically have the clients in separate spaces, and maybe the whole team goes back and forth.
Right.
So just knowing when to be flexible has been my personal growth, I would say. And sometimes if we want to do it right, then some professionals are like, well, no, wait, this is how I was taught to do it. This is the roadmap. I can't veer from that. But knowing when it might actually be beneficial to veer from it can be important too.
And another piece of that is the fee shifting piece that you talked about. Sometimes you talk to a client and you do a consult and you say, okay, well, tell me about your finances. Tell me about everything. And so you talk to them, you get a team together, you get a collaborative case started, and your neutral financial professional starts gathering financial information and says, these people really don't have a lot going on. At that point, you pivot as a team and you say, okay, well, let's take this offline. Go talk to them about options for how to divide what they've got, rather than having a bunch of big team meetings that are going to cost them money that they don't really have. So being able to be flexible in the process in a lot of different ways, and being able to shift fees to, as you said, the neutrals who have usually a lower hourly rate can really, really benefit clients.
Yeah, I like that. The offline meeting is what we typically call that, meaning any group smaller than the 6 of us.
Right.
And the mental health usually does all of the parenting plan without the lawyers there. The lawyers are talking to their clients individually, perhaps, and then it all comes back to the lawyers for annoying lawyer questions and approval before it's finalized. But that saves them a lot of money because they're paying one person to do, and that could be 3 meetings with that person. It could be 6 meetings with that person, depending on how quickly they make decisions, what all they want to include in their decree. But they could do the same on the financial, to your point, with a financial neutral. And if it's not as complex of an estate and there's less need for lawyer brain on it, the lawyers would still approve, the lawyers would still be informed of what was going on, but that could help them to save a little money. So that's important. Why do you think clients like it compared to litigation? What's been your experience?
Really, who wouldn't want to take control and to make decisions for how you're going to raise your children together with the person who you're going to co-parent with, even if you're not going to be married? Who wouldn't want that experience versus meeting a third party who you probably or maybe didn't vote for in a general election and asking them how you're going to co-parent your children moving forward? They don't know you. They don't have time to know you. They have 10 other cases that day.
A stranger in a black robe.
Right. And I love our judiciary. I really do. They have a thankless job. But I don't know why parents, I don't know why people who are, even if they don't have children, who are just getting divorced, why they would want to go ask someone else what to do with their stuff when they can figure it out themselves.
One thing that's been interesting to me is at some of our conferences, we've had panels of people who've gone through the process, like real life humans who did this, who were nice enough to come help us learn more. And they've all talked about reasons that they like the process. And it never occurred to me that privacy would be so important. But a lot of people like the process because it is so private. Has that been your experience too?
Yeah, absolutely. It really speaks to people that you have the opportunity to resolve your differences, to settle your disputes in a forum in which no one else is hearing it. You're not airing your dirty laundry, if there is dirty laundry, but you're not putting it out there in the public. And privacy is really, really important to people.
I thought if you weren't famous, who cares, right? But that these people weren't famous, and they were like, I really valued the process and wanted to do it partially because of the privacy element.
And dignity.
Yeah.
The process really helps both clients to maintain dignity and to amicably resolve things. There's really not a whole lot of dignity down at the courthouse.
That's true. The other thing I've noticed is that professionals are attracted to this work for different reasons. And I loved it when I first heard about it in 2001 because of the creativity it allows. That we can really not just do the cookie cutter that you'll get from the courthouse. We can do something that is creative, that fits this family, both on the parenting side and on the financial side. And some people professionals don't care about that at all. They're very satisfied for it to be the same result that you might expect to get at the courthouse, but they value it for a different reason, and one that I've heard is control, that this gives these two people control instead of the stranger in the black robe, and not just control over the outcome, but control over the pace of the case. We've had cases where they have a life event happen that has nothing to do with their divorce, and they need to shut down this process and go deal with that. Maybe one of the children has a crisis, a medical crisis, a mental health crisis. Maybe one of them needs to go to rehab and deal with that.
Right.
And that's not a luxury provided for in a court model.
Right.
But it is, you have control over the process. Reconciliation, if they want to stop down and say, maybe we can go reconcile. Very few cases in litigation doesn't improve your relationship typically.
Right. You have to make that call pretty early.
Yes.
If you end up at the courthouse at all, then you're probably not reconciling anymore.
But collaborative, actually, I've had collaborative cases where it's actually improved. They've improved their communication through the process. Now, I wouldn't be selling it like come in collaborative and stay married, but
right.
But much more
it's
likely.
Not a reconciliation vehicle.
No,
but it does happen on occasion.
Yes, so that's good. I think one myth about collaborative is that you have to be all holding hands and saying kumbaya to do it.
I don't think I've sung kumbaya since I was like 6 years old at Boy Scout camp or something.
Kumbaya necessary.
No. It's actually much harder than litigation. It is a lot harder to, as clients, to really focus on what their interests are and to come to a resolution. It's much harder as attorneys to work with your clients and really reach across the table and help the other client as well and help them to resolve their differences. It's much easier to just go down and say, I've got 30 minutes. I'm going to put on as much evidence as I can, and the person in the black robe is going to make a decision for me. That's all I need to do.
I've had cases where they hated each other's guts in collaborative, and they slammed the doors to the conference room so hard that I thought the glass next to my door was going to break. But they still were able to resolve it within the collaborative process. So I do tell people it's a more amicable process. And if that's important to people, they definitely can be their higher selves and be amicable, but it is not required.
Right.
They could value the process for a different reason and carry on hating each other. And I've had cases where they didn't speak to each other outside of the meetings. That's the only time. And they needed that level of assistance from a team in order to get it done. So it was going to be a team helping them or a judge helping them. There was no way they could do it directly. Right. So it's not all just people who, get along great.
No. A lot of times it's definitely not.
So in my practice, and I imagine in yours, I'm hearing a lot of, well, he's a narcissist or she's a narcissist. Have you ever dealt with that? And they're gaslighting me. Those are the two de jour terms of what's going on. Can people who, I'm not saying they're actually diagnosed any of these things, right? This is just their spouse's perception. Can those people do this work?
So the best thing about this process from that perspective is the fact that you are signing a contract with your spouse for full, open, honest disclosure of all information that's relevant to the resolution. It is a transparent process. And if one party or the other, if one client or the other cannot fully disclose all the information, you've got a full team of people there checking everything and making sure that everything has been disclosed. And the biggest thing is that if push comes to shove, Texas case law has upheld the enforceability of that contractual obligation to fully disclose all information relevant to the settlement.
Yeah, that's a big deal. Because the other thing everyone says is he or she is hiding money.
Right.
So are we going to get more information or less information in collaborative?
I really feel like you get more better information much easier.
I agree. 100% agree.
You know, because in discovery, you ask for everything and then somebody doesn't give you something. And then you either have to go to the courthouse and say, okay, well, force them to give it to me. They say it doesn't exist. Your client says it does. You know, they're hiding money. They're, you know, whatever it is. You never know that you're getting everything. You never know that you have everything. At least in collaborative, you've both contracted to provide everything.
Yes.
So if you find out about something later, you might have a better way to actually
do something about it.
Yes.
Chris, where do you office?
So my office is in the newly relabeled the Guild. Used to be Campbell Center. It is directly across from North Park Mall on North Central Expressway
In Dallas.
in Dallas. So
Do you service broader than Dallas?
I do. I have cases in Tarrant, Collin, Denton, Ellis. I've had cases in Bexar County down in San Antonio. I've got someone I'm speaking with this week who's got a case going in Bell County. The great thing about collaborative, if it's a collaborative case, is that with it, you know, when 2020 came and we weren't meeting in person, we've all learned to use Zoom.
Yes.
And with Zoom, I can practice all over the state without the client incurring all the fees of me flying to Midland to go have a hearing or something of that nature.
Yes.
So it really has opened up the borders of our counties and allowed collaborative practitioners particularly to be able to practice in different counties without the additional expense of the travel.
Yes, agreed. So pretty much any place in Texas, but you're licensed in Texas. That's where it needs to be.
Yes.
We're going to put on the screen how to reach you.
Okay.
Thank you so much for being with us today.
Melinda, thank you for having me.
It's been a pleasure. So that's it for this episode of the Melinda Eitzen Show. Thank you for tuning in, and we'll see you next time.